Hi everyone, thank you for joining us today. My name is Eleanor Lewis and I'm a research analyst at the Legal 500. Today's webinar is titled The Evolution of Competition Law Theory and Practice. What's next? So I'll keep it brief and hand straight over to Mr. Gurkainak.
Thank you very much. And thank you everyone for joining. We have two distinguished academics attending, and also they have experience in the enforcement side of things as well. You see Spencer Weber-Waller, professor, and also he was the senior advisor to the chair of the Federal Trade Commission in 2022. Obviously, what he will say will not be binding on either the Federal Trade Commission or any enforcer, but that experience is extremely relevant and interesting. Spencer is the John Paul Stevens Chair in Competition Law and Director of the Institute for Consumer Antitrust Studies and Professor at Loyola University Chicago School of Law. He's a good friend of mine. He goes way back in looking into jurisdictions other than the US. He has always been a global citizen of competition law thought. And then you have Yanis Lianos, who is currently the president of the Hellenic Competition Authority. And he is a professor, chair of global competition law and public policy, and founding director of the Center for Law, Economics and Society at the Faculty of Laws, University College London. On top of his position at UCL, as he is currently the president of the Hellenic Competition Authority in Greece, obviously what he will say will not have any bearing on the approaches of his institution either. He was awarded the Philip Leverhulme Prize for his seminal research, and he's a laureate of the French Academy of Moral and Political Sciences. He is the co-editor of the Journal of Competition Law and Economics and of the Yearbook of European Law. Speaking about those kinds of positions, Spencer Weber-Waller is a member of the advisory board of the American Antitrust Institute, and he's at the editorial board of the Antitrust Law Journal. So I'm really privileged to be in the company of such great minds of competition law from both sides of the Atlantic. And today's exercise really is to keep it loose and give them room to maneuver in discussing where are we coming from and where are we heading to in terms of competition law enforcement and in terms of the evolution of the intellectual side of competition law matters. I will be putting some questions to them, but when we were doing a very brief prep, Spence said, you know, I might be putting questions to you as well, and I said, be my guest. So I might, from time to time, leave the traditional capacity of a moderator. Yet I think it's way more interesting to hear these two panelists speak. Your questions are also going to be conveyed to them. So to the extent you have any questions, please write them to us, and we will see and we will discuss these questions as well. To kickstart things, allow me to ask the first question I wanted to ask, since we're discussing the evolution of competition law. One evolution that is happening in the markets is an evolution toward digital markets. And digital is becoming more and more interesting, also for competition law agencies. That's not even a new thing. But a discussion that is from time to time happening is, could the focus on enforcement in digital markets be leading to under-enforcement in other sectors? Obviously, when one asks this question, the first thing one discusses internally is, well, a lot of markets are already converting into digital markets. So one way or another, that kind of focus on digital markets should still be bringing a healthy competition to the dynamics of that particular market too. But there are markets like cement or construction materials or chemicals or agriculture, some of foodstuffs that aren't that digitized. And could there be a discussion that with the quick evolution of the markets into digital and the competition authorities jumping into enforcement in that field, basically more brick and mortar quintessential markets fell off the radar screen? Or could it be that the capacity of antitrust enforcement agencies expanded in parallel with the expansion in digital? So there is enough room for enforcement everywhere and no one is observing that kind of a potential problem. Allow me to ask this to Ioannis, and then Spencer would proceed. As you will realize, it will quickly turn into a chatty environment. So, it's not going to be that I ask a question and in a structured fashion, one answers and the other. We'll keep it conversational. Ioannis, please.
Well, thank you very much, Gionang, for the invitation. It's a great pleasure to participate to this, and with excellent company with my friend Spencer Weber-Wyler. And of course, whatever I say today, these are my personal views, and as you said, they do not engage the Hellenic Competition Commission. So in terms of your question, I think, it's a matter of looking a little bit to what were the issues that have been concerning the competition authorities the last few years. I think the digital revolution was an important legal irritant, if I can actually use that term, because, we had to deal with the emergence, very quick emergence of the big tech companies, which obviously have economic power that is not related only to a specific market, but actually because of the presence and the dispensability of these big tech companies, they might attract some, to a certain extent, they might actually have power, which comes out of the possibility of the orchestrate ecosystems. So that was a legal irritant that led to a number of reflections of competition authorities. They commissioned a number of reports back in 2016-17. Some of them have actually moved to enforcement, but there hasn't been much of an enforcement apart from the European Commission and, of course, the German Bundeskartellamt. I mean, the French competition authority, as well as the Italian competition authority, has done some work in Europe, but actually the rest of us haven't really enforced with regards to these digital companies. And of course, now with the DMA, that somehow leads to different methods of enforcement. Now, as you said before, also the fact is that everything is digital. I mean, we have platforms that are actually hybrid. Take the example of Airbnb or agri-tech platforms, which are used increasingly in smart agriculture. So, I mean, you have a digital component, you have a non-digital component. So from that perspective, I think, we'll probably expect enforcement activity there. But I have to say that in the recent months, in particular, because of the inflationary tendencies, we have seen somehow a refocus on the more traditional areas of competition law enforcement, in particular in the food sector, for instance, as well as possibly in the construction sector, as you mentioned before. So I think it's a matter of the important issues that come out because of the evolution of the economy that lead the competition authorities to make choices with regards to the use of their resources. So, the digital revolution definitely is an important area that we are focusing on. But right now, we also need to focus on other dimensions of competition enforcement. So from that perspective, of course, the way we're going to use our resources and the way we're going to prioritize our cases will be dependent on also the availability of resources, and also the fact that you might have a reallocation of tasks between the European Commission that could possibly focus on the digital sector, in particular the big tech companies, and the national competition authorities in Europe that could do work in more traditional sectors, as well as, of course, in the digital, but cases concerning, for instance, e-commerce or platforms that are not gatekeepers. So a reallocation of tasks between us could possibly, I think, be more efficient.
Thank you very much. Spence?
Yeah. Hi, everybody. Thanks for having me on this. It's great to see both of you. I'm sorry we can't do this in person. Let me just say, same disclaimer as Ioannis has said, I did spend last year as a senior advisor at the Federal Trade Commission. I'm appearing here today just in my academic personal capacity, and nothing I say represents the views of the FTC, the chair, the staff. And when I talk about things at the FTC, I'm limited to things that are in the public domain, publicly available information. With respect to your really good question, yeah, these cases are extremely important, extremely time consuming and resource, and even agencies as large as the FTC. Now, I worked on the policy side, so I was not part of any case teams, but you know, there's only so many people you can put on any given investigation, given the full range of what the FTC does. And you know, they have something like 1,000 or more professionals, but again, more than half are engaged in consumer protection and privacy related matters. On the competition side, there's litigation pending against Facebook with respect to prior acquisition of WhatsApp and Instagram and other pending mergers that are being litigated. These take up a tremendous amount of resources. But you know, there's a wide economy out there. And if you look at what DOJ and FTC are doing, I think they're really doing their best to pick and choose the cases that matter across the full range of the economy. For example, the FTC has a recently filed case that involves a program of bundled rebates and de facto exclusivity involving pesticides, which really isn't, again, about a digital platform. Obviously, it involves certain aspects of digital commerce. The Justice Department has a relatively small criminal indictment recently against some sellers of DVDs over the internet who apparently are accused of fixing prices. And while obviously it relates to e-commerce, it has nothing to do with the issues of digital platforms that are attracting all the attention. And so, you know, it's a mixture. And again, if you look at the announced priorities, the Justice Department and the FTC in bringing renewed attention to injuries to labor as antitrust violations, a variety of cases involving no poach agreements, wage fixing, non-compete agreements that have been the subject of FTC enforcement action, and a proposed rulemaking that would ban most non-compete agreements in employment contracts in the US. You know, these are things that are really important. And I think whoever's at the top of any agency has to, and Giannis is in this position now, and I was never, but you know, has to really think long and hard about how to allocate resources to do what's going to do the most good. And I think there's a room for small cases. I'd be curious in Giannis's view, but they're mostly used to make new law, get attention for old law. And so, you know, you wouldn't think that this DVD indictment has particular great economic significance other than its deterrent value way beyond the specific firms who've been accused of this. And nothing's happened. The trial hasn't taken place yet. But, you know, you look at these small cases and you realize you have to bring some of them, but you can't bring all of them. And so you're mixing and matching, and they're, you know, we know there's litigation brought by the Justice Department already against Google, and there's litigation and there's public information that there are, you know, other investigations of Amazon and Apple going on in the United States, and the rest of the agencies, and remember the private enforcement is on the full range of economic activity.
Interesting. Thank you very much. I'm sure the audience will want to ask questions as well, but allow me to continue with what I have in mind, and as they punch in their questions at the Q&A side of the screen, I'll be happy to be the conduit through which these questions flow to you. One question that is easy to ask and is interesting to observe, since we're discussing the evolution, is that truly there are some steps that are taken in the antitrust world that bring into the forefronts of antitrust enforcement certain concepts that were really not seen as important. We were all flying over it. Non-solicitation has been one of them. Non-solicitation was always a thing. We would have always discussed this in a, whether it's an ancillary restraint or not, kind of a capacity, but no one really expected full-on enforcement that is targeting non-solicitation, no poach type of arrangements in different jurisdictions just until, say, 5 years ago. I'm actually keeping it quite long. I could even say maybe 3 years ago. And then the US has started showing attention to it. The EU has started showing attention to it. And I'm looking at it from the perspective of a general counsel who has been doing, compliance work for decades. Sure enough, this person is going to be sucker punched by this sudden evolution of antitrust to jump on a new topic. I don't mean to have you discuss non-solicitation where it is today, if you wanna, obviously, but more interesting to me is what do you think could be the new non-solicitation, i.e. something that you suspect is brewing in there, something that is not getting that much of an attention, but it may actually become a central issue for antitrust enforcement. I know that I didn't give any pre-warning about this particular question when we were doing the prep. I thought of this question yesterday, and sorry for that. But whoever wants to take it on, I'm genuinely interested in the response, because with all the experience that you have, you must have had the feeling that something is actually showing a lot of potential, but is not getting its full value at the moment, and it may become a headache, or it may become an important topic of enforcement. Whoever wants to take it on first.
I mean, if I may intervene here, you have, of course, the policy and academic debate that sometimes that always precedes a little bit the enforcement issues that you raise. I mean, with regards, for instance, to labor and labor markets, I mean, this was a concern that was expressed by a number of authors before basically the various competition authorities, first in the US and then in Europe, starting dealing with one of the aspects of labor markets, which is actually the poaching agreements, which is the horizontal aspect. Of course, there has been a story here that precedes basically this debate. Labor markets was any particular labor market power or monopsony, actually, at the labor side, was something that was discussed decades ago. I mean, John Robinson, for instance, in his work in the 1930s, have been raising this issue. I mean, of course, this was forgotten for a long period of time. And the reason I think that came up was that a number of academic circles were interested in the sense that productivity was increasing, but then an important part of that, the surplus value of that productivity increase wasn't going to labor, and that raised concerns about are we really, should we focus more on the labor markets, in particular in view of the fact also that many of these platforms have monopsonistic positions, monopsony positions. So with regards to that, I would say, I mean, the recent discussions about sustainability, which I think offer, and in particular, the related issue of industrial policy considerations in competition enforcement, I think, could be issues to ponder in the next few years. I would say the same about the use of new, approaches like complexity science in competition enforcement. I think this will generate a sort of a revolution in the sense that in the way that we are collecting evidence, we're assessing evidence in the context of the competition authorities, also with regards to the evidential standards that competition authorities might have in cases, and the way the courts will deal with cases which are coming with evidence through like not the classic econometric or economic models, but actually big data type of evidence or complexity science based evidence. I think these could be interesting issues for the future. But maybe Spencer has other suggestions here, and I can think of many more in the next few minutes.
Yeah, I agree with Yanis, but I have a couple other things that I think may reflect my US focus, despite my interest in other markets and other jurisdictions. One is, I don't know if this is what you meant, but one is the goals of antitrust. It's been a 40-year cycle of predominantly a consumer welfare Chicago School approach in the United States. And there have been voices, myself included, Giannis and others, both younger and older than us, who've been arguing the other side. But for the moment, there's folks who've had tremendous roles in these debates who are in charge of the agencies now, including Tim Wu, who's left the White House, but Lena Khan at the FTC, Jonathan Cantor, and various voices in academia and in a non-governmental sort of anti-monopoly movement that I think is really important. And the issue for them will be whether these changes stick, which will involve at some point changing the nature of the judiciary in the United States, or persuading a conservative, skeptical judiciary to be open to more theories. But as the specific inside antitrust, the labor and monopsony stuff, I think, is going to get a huge amount of attention, which wasn't the case 5-10 years ago. There's a recognition that labor markets in a lot of areas are very, very thin, and that, for example, poultry and meat producers often face a single buyer because it's sort of a local thing. If you're raising chickens or cattle, you may not have a choice by geography other than dealing with one or maybe two processors. And so also, it is a huge sea change if the merger guidelines that are under discussion, under revision, if they include a different kind of discussion of labor issues, all of a sudden mergers that produce savings through firings or wage reductions, if those emerge as, in essence, not a defense anymore, but as a confession, that's a huge change and a really important one. And I'll add one more besides the emphasis on non-competes. Again, nobody thought much about them except as a potential rule of reason violation, but the evolution was smart in a way. So maybe people feel blindsided, they may, but it's been an evolution from a petition to the FTC to do something, to hearings within the FTC, to civil cases from the FTC, to a proposed rule. On the non-solicitation side, which you've talked about, same idea, where a civil case was brought, a guide for human resources was put out, warnings were brought that they would be prosecuted criminally if things continued. Private litigation has played an important role in seeking compensation for these things. And then it's only recently that the Department of Justice has brought some criminal cases with different results, depending on the facts. So you can see how they've been rolling this out such that they didn't start with criminal prosecutions or dawn raids or FBI and anything like that. I'll lay out one more. We can talk about maybe why sustainability is or isn't the same degree of penetration into US antitrust. Let me throw one on the table. Again, recently, in different ways, people in the US for the first time in recent memory are beginning to look more abroad to see how notions of abusive dominance can be worked into the existing Section 2 jurisprudence, or perhaps changing that by legislation or rule.
Interesting. Yeah.
I mean, out here, I think there's a lot of cross-fertilization. I mean, issues that were mostly, attracting attention in the US in the past, like, invitations to collude or price signaling through the Section 5 FTC Act, now are becoming more and more interesting also on the European side. I mean, we have in Greece a new legislation that actually puts forward this price signaling and invitation to collude. And, there's all this discussion about a number of competition authorities in Europe adopting something like the market investigation reference tool in the UK, which will deal with these issues of oligopoly, where you cannot really enforce Articles 101 and 102, but you need to have some form of intervention. So I think this is an issue that is now in Europe quite significant. And more generally, with regards to the goals, just one thing. I think that we see across the Atlantic a shift, a paradigm shift. I mean, from the I would say the classic law and economic approach, or neoclassical price theory approach, to what some authors have called the law and political economy synthesis, which is basically a broader source of social research type of analysis, sociology, economic sociology, or political economy, that has different, basically, the different focus on issues of power, multi-level governance and pluralism, equality and democracy. And I think these are issues that are becoming quite important in the US, as far as I can see, but also increasingly so in particular parts in Europe. So I think these are issues to think about in the future.
So I'm just curious, do you think the jurisdictions that you're most familiar with are seeing the same development, which in the US we mostly call either the neo-Brandeisian or sometimes the long political economy that you were just talking about? Do you see the same kind of changes in
I will
the
not
last few years?
I don't think it's the same extent, but there's a very lively debate also in Europe with regards to these issues, and some competition authorities are more open than others. Okay, so but I think definitely it's an issue that, well, the goals of competition law has been set. I mean, in my own work, I've been, putting forward this polycentric competition law model. And I think to a certain extent, we see some inroads in that. I mean, with the fact that, we take into account different parameters of competition than price output. I mean, privacy, sustainability, stability, resilience, all these issues are coming in. So yes, I think, we are moving towards that. I mean, the labor issue is also quite interesting. I mean, in Europe, we have this collective bargaining possibility, in particular with regards to digital platforms. So, so I think increasingly so the various competition authorities want to engage with these debates, but different extents.
The labor issue is truly interesting because I'm remembering from my own experience, we had written an academic piece, which then got published. I see it in front of me now. This was called Competition Law Issues in the Human Resources Field. And we published this 10 years ago in the Journal of European Competition Law and Practice in April 2013. We've published this. I remember the journey of publishing it. It was a good piece. And today it would be considered as, they're looking into something that needs to be looked into. Back in the day, a lot of journals were taking, isn't it quasi understood to be exempt from competition law? Is there any juice in this, and all that? Ultimately, Journal of European Competition Law and Practice had published it, but I remember noting mentally that, we may have gotten into a field that is in people's minds seen as almost exempt from competition law enforcement. And then suddenly, well, not so suddenly, but in about 5 to 7 years from that, it has walked into the forefronts of competition law enforcement. It's interesting. So one question that I really am interested in terms of the evolution of competition law, because throughout my career, I have seen a huge shift, in my view, is the positioning between the US and the EU in terms of both the enforcement and regulatory side of leadership and the intellectual leadership. A case could be made that the intellectual leadership is has still not moved from the US to the EU. It may not, but I guess on the enforcement and regulatory side, there are at least quite a number of sub fields of competition law or channels of competition law where undisputedly the EU is the locomotive of enforcement and regulation. Now that's for younger people who are following us. They may be interested in knowing certain anecdotal things. For example, back in 2001, when I was practicing in New York, you had in the merger control field, you had the GE Honeywell, very recent. Then in 2002, I was still in the US practicing antitrust law. There was Air Tour's First Choice. Microsoft One was happening in the EU already. So I think it must have been August 2000 that the first statement of objections in Microsoft One was delivered. And it felt different from the US case. And then it was found out in March 2004 that it was actually different. And I ended up actually moving from the US to the EU to take part in that defense of Microsoft. And, you know, back in those days, 2001, 2, 3, 2004, too, I'll say, the understanding was that the US is doing this in a very sophisticated manner. The economic analysis is way more sophisticated. The enforcement underpinnings on the economic analysis is much better built, and the EU is trying to catch up with it. Fast forward 2 decades, now we're in 2023, and a lot of shots are being called by the EU. There are certain fields where, like sustainability and competition law, for example, the intellectual leadership is with the EU as well, on top of the regulatory and enforcement leadership. You could say that data protection and competition law, privacy issues and competition law, these are all also handled more as a, you know, groundbreaking forefront enforcement in the EU. Question is, why is this shift happening? Is there reason to expect that this particular shift in gravitas will continue? Is this a conscious preference, or is it something that is naturally happening because of the evolution of businesses and other regulatory fields? What is your take on this? Maybe this time with Spence first, and then Yanis.
Sure. I've written about this in an article that I've called "The Omega Man or the Isolation of U.S. Antitrust Law." The Omega Man, by the way, is an enjoyable but bad science fiction movie with Charlton Heston from the 1970s. It's a metaphor. I don't have time to get into it, but the reality is, yeah, the United States has been isolated from the global conversation, particularly with respect to the unilateral uses of power by single firms. There has been a relentless retreat as to the scope and application of Section 2 by our Supreme Court in the last 30, 40 years, culminating in the Trinco case, which to me had shockingly praiseful language for monopoly power in a case about whether or not it had been abused. And as a result, that puts the US in a corner where the rest of the world, for a bunch of reasons I lay out in the article, and I think most of the people on this call are more familiar with, the EU has a leadership position and a model to deal with the abuse of a dominant position as the way to deal with single firm conduct. It's not perfect. Their critics can be used wisely or poorly, but that's a model that obviously applies in the EU, is adopted by the member states who can even go further, and is as a matter of formal legal obligation or just persuasiveness, adopted by many, many trading partners of the EU. Next to nobody approaches the enforcement of antitrust to single firm conduct the way we do on Section 2. We're in a corner, and I think past administrations have made it worse. This is both Democrats and Republicans. If you go back to who was in power at different times, including GE Honeywell, the US has spent a lot of time and energy yelling at the rest of the world that they're doing it wrong, and sometimes doing so in very offensive and personal terms. And I'm pleased that the current administration appears to be adopting both different substantive ways of looking at the law within the framework that we have. There's legislation that would change the actual wording. New York State has a bill that would actually introduce literally the abuse of a dominant position into the state antitrust law, things like that. But separate from what we're trying to do in baby steps to make our law and policy closer to the rest of the world, we're coming to international meetings and conferences, both the public sector, private sector, NGOs, and we seem to be doing a better job of trying to listen rather than to lecture the rest of the world.
Interesting. Yanis?
I think it's a issue of investment. I think in R&D. I mean, the U.S. has done a major investment in antitrust enforcement in the 1960s, 70s. Then it shifted, towards this more economic Chicago approach in the 80s and the post-Chicago in the 1990s. So there has been a lot of interesting research that led also to different policy options and enforcement. So there was a lot of things going on in the US, a lot of lessons for the EU. I mean, many students, and myself included, moved to the US to study this more economic approach to competition enforcement, as we call it in Europe. I would say, however, since the early 2000s, there has been much less investment in the US in antitrust law enforcement. I think we, and obviously Spencer might confirm that, I mean, we had less and less courses in antitrust enforcement, less and less investment in academia, I mean, new hirings in antitrust in American universities. But in Europe, we saw an increase of the investment in competition law, in particular, after the implementation of the EU merger control in the early 90s, and the move towards this more economic approach, starting with merger control and then moving to the other fields of competition law. So Europe has invested considerably in terms of education and research in competition law, and of course, at the same time, with regards to the enforcement, as you said, Yonenk, I mean, the Microsoft case in Europe was a little bit some kind of follow-up of the 1990s American debates, of course, leading to different outcomes. But since then, I would say, the European enforcement has skyrocketed. I mean, we have seen very interesting cases, not extremely innovative, from the different versions of the leveraging theory, but still, I think we have seen some enforcement, some reflection. And I will say, I mean, in the 2010s, we have seen in Europe different approaches coming in. I mean, after the more economic approach or more technological approach, I mean, if we can use a term of a colleague, we have seen, the greener approach or the polycentric approach, which actually tries to deal with a number of issues like privacy, other dimensions of social sustainability, which became the focus of the European academia, which I think is quite innovative in this area. And then, I would say it's only the last couple of years that in the US, we have seen, some reinvestment in the antitrust, issue, I mean, the antitrust field, which doesn't really come from the people that were actually doing antitrust work. It actually comes from mostly outsiders. I mean, there has been a lot of research in by people that haven't been really in the in the antitrust group originally. I mean, people that were doing constitutional law, people from the NGOs, different institutes, etc., that have been thinking about the evolution of capitalism, and then they obviously included antitrust as one of the dimensions of their broader study. I mean, that was a more transformational study about the whole, the whole legal system, not just competition law. And we have seen actually a lot of investment there in the last few years in the US. And obviously now with the new leadership at the DOJ and FTC, we see also more enforcement coming in. So it's not easy to make predictions about who is going to be the enforcement and the intellectual leader of the future, but I would say it will be a very close game.
Yeah.
I think the real issue is there's strong evidence of real interest in progressive change. And the question is, how do you make that stick? Some of it is just dependent on elections, but within the intellectual communities, it means something more. This is not just who's in office. Many of these changes, in fairness, started during the Trump administration. Yeah. The interest in labor issues predates. Well, it's Obama, Trump, and now Biden in the United States. It comes from labor law scholars who suddenly realized that antitrust had an important aspect for their work. And so how do you make these progressive changes stick? In the US, one of the nice things is this whole of government approach that the Biden administration has adopted by executive order, where you try to come up with creative coalitions of agencies, enforcers, and powers to tackle things that matter in the real world. Some of it just has to do with the prosecutorial discretion of our agencies. Some of it has to do with how do you interact with the public at large, not in addition to the legal public that we're probably talking to today, but how do you convince people in the real world that antitrust matters and is in their best interest, who aren't going to be aware of the fine stroke differences between a neo-Chicago approach and this and that? And this cuts against, by the way, just solely focusing on digital markets. You want to persuade the average person that antitrust matters and that you should support government efforts to do the changes that are going on, in part, you have to go after things that hurt their bottom line kitchen table interest, whether that's food, whether that's construction, whether that's transportation, whether that's fuel, whatever it is. And so, you know, you have to pick and choose.
Yeah.
And tell your story in a way that makes sense. And, you know, I'm very proud of what I'm seeing some of the government agencies do to tell their story, because the rulemaking against non-competes is controversial. I don't know when and how it will be finalized, because it just was proposed very recently. But, you know, it's nice to see the decision makers. It's even nice to see the people who think this is a bad idea. It's nice to see them on the national news and the front page of the newspapers, not just in the law reviews and the legal conferences.
Yeah. Yeah.
And if I may add to this, I mean, you know, we don't have to obviously focus only on the progressive side. I mean, I think we can see very interesting ideas, innovative ideas as well at the libertarian side of the spectrum. I mean, I think it's quite, you know, what is really happening is that both in Europe and the US, you basically see more and more of a approach of dialogue in a way coming in between different tendencies, you know, the more libertarian one from one side, the more progressive one. And I think that's very useful, because that will, you know, it's very good if things are debated. There's a broader policy debate to which different stakeholders contribute. And I think that's the enrichment of competition law that comes out of it. So we should welcome this type of dialogue between different camps, if I can use that term.
It's also interesting to observe that probably the wedge between the enforcement preferences at the two sides of the Atlantic has never been bigger or stronger than the sustainability debate. And that begs for the question of what the two of you feel the future of sustainability discussion in competition law is. Maybe put differently, have we already realized the full potential of the sustainability debate in competition law? Because sustainability in and of itself has become so important for the overall evolution of humankind that it has made very heavy inroads into competition law, but actually it is ahead of the demand in competition law. Or could we say that this is just a prelude, and actually there is way more room to improve in terms of the legislative infrastructure? Maybe subsets of the question is the issue, so we know that the issue is real. The sustainability matter is real, there's no discussion about that. But is the antitrust relevance being exaggerated? Is there really an antitrust angle to it that required all the guidances and the exemptions, whatnot? Is there demand from businesses for this guidance or these exemptions? Or are we jumping on this subject because it's important and hip, so it has to have a reflection on competition law? Yanis, maybe?
Okay, interesting question. I will say, you know, you're both right and wrong in the sense that, yes, maybe at the beginning of this debate, that really, you know, wasn't really an important issue a few years ago. I mean, I remember organizing a conference back in 2018 in Brussels with the participation of the commissioner, as well as a number of green and you know, ecological type of, you know, movements, and this was really a new issue at the time. Even if, you know, a number of our my colleagues have published work in the past about, you know, green and competition law, and they have been extremely important in the discussion. But you know, it was a new issue, and you know, look, 6-7 years later, I mean, we have so many discussions about sustainability. We have so many competition authorities and competition law systems adopting specific statutes that will accommodate, you know, the sustainability competition interaction. We, you know, the Atlantic Competition Commission have been playing quite an important role there also to promote sustainability concerns, the sandbox, etc. And of course, there's been some exaggeration probably in terms of the interest of the business community. Yes, I mean, there's been interest from the business community at the beginning. Probably, we see now, and we're waiting to see, more, the businesses coming in and using these tools like the Sandbox or the guidelines. But I think, it's a matter of time for this to develop further. But we all understood that this was a moment where the competition authorities could possibly bring forward this new issue of sustainability. The green transition was a very important issue in a number of countries in Europe. And to a certain extent, we're acting in conformity with the broader, basically, Green Deal type of, objective that the Commission actually had. So I believe that this is an important issue, and we'll probably see more of that. It will start with really at the beginning of the whole process. And of course, there are other risks of the greenwashing, etc., that many have put forward. But I believe that there is a lot of potential there to develop this, and in particular, to disseminate as well green technologies around the world. So I mean, it might, right now, it's a kind of a first world issue, if I can use that term, something that the competition authorities in developed countries are focusing on. But I think, we need to think more broadly about the dissemination of these green technologies and this transfer of technology also in a number of other jurisdictions, emerging economies and the developing world, because we're talking about, a global transition to the green economy, because otherwise we don't do that globally. I mean, there's no point. Climate change is a global issue.
Yeah. Ben?
It's really hard for a U.S. antitruster to. We don't have a leadership position on this because of the way our antitrust laws have been interpreted. So I love to torture my students with two versions of kind of the same thing. One would be, what if all the toy manufacturers got together and agreed to eliminate lead paint because of the health concerns, lead paint on the toys? And then more realistically, what if all the car manufacturers agreed to stop manufacturing gas-powered cars by the year 2035 or whatever it is, just make only electric vehicles now or then? What would you do about it? What could you do about it? And any of those things run into a tradition in US antitrust law that we look at the competitive effects and we don't take into account general social welfare concerns. There's no social welfare concern more important than sustainability. But the problem is there's strong case law and no equivalent of 1013. There's strong case law that says you're answering the question of whether this arrangement does or doesn't harm competition. And the fact that it achieves some other goal that we all like is not within the sphere of antitrust. So what it means is, for the US, we are more dependent on legislation, which isn't going well right now because of political gridlock and other controversies that make it hard to do. And we're doing the best we can. We play a role in international diplomacy on climate stuff that I'm not an expert in. But from an antitrust standpoint, the best we can do right now, absent new tools, is to use a little prosecutorial discretion. And in my view, avoid situations like in the Trump administration, where they were looking at potential agreements between car companies to continue to adhere to some higher mileage per gallon standards for their vehicles when they were no longer legally obligated to do so for administrative law reasons. That case never went anywhere, but in my view, was not a good use of resources. I also thought it wasn't actually a violation of the antitrust laws, and no further action was taken. But at the end of the day, we don't have an easy mechanism. And again, for a variety of reasons, the EU is in a better position to do this. But we don't have a way of saying, sure, this might harm competition, but it's worth it in terms of the sustainability.
If I add here, I mean, it's a matter of the institutional differences between the EU and the US. I mean, the role of courts in the US is predominant in the enforcement of US law. And courts, obviously, they need to adjudicate the specific dispute they have in front of them. I mean, they cannot necessarily take into account these more polycentric type of issues like sustainability, either environmental or social. In Europe, I think, we are mostly relying on competition enforcement authorities, so public enforcement. These are technocratic type of institutions that have integrated, different types of learning. I mean, economics, now data science, and potentially, they might also integrate sustainability-related type of issues in their personnel. I mean, with the Dutch authority, the Greek authority has published a technical report about, evaluating sustainability arguments in competition enforcement. So, this is easier to do in the institutional context like that of the EU than in the US, court-centric system of competition law enforcement.
Well, the analogy that I would say is, I think you're right. I think you guys are the leaders for all the reasons you said. When the US has taken the lead in integrating labor into antitrust, it has required reframing it as traditional antitrust issues, not an exemption from or a different way of saying yes, but it was really just saying, you're just missing the right frame. It's a traditional monopsony frame. It's a traditional merger theory to the labor market rather than a product market. So, we had to jump through those hoops, and maybe we're ahead of the rest of the world on these issues. Maybe we're not, but we're clearly behind on sustainability. And I know that the first time I really learned much about that issue, gave it much thought, I was doing some teaching in England at Oxford, and I was co-teaching with Simon Holmes, who was a distinguished antitrust lawyer, judge, and teacher, who was writing a stream of scholarship that continues to this day about how to do this in antitrust, sustainability and antitrust, using all the tools that you said. And I just thought, wow, I hadn't heard about that in a US antitrust context before. And now I'm finally, beginning to get more understand why. And you have a first mover advantage, and it's gonna continue for a while.
Yeah, that's right. So on the topic of evolution of competition law, obviously we can't do without a more direct look into the evolution of the prime objective of competition law. Now, we've talked about it. We've given examples in the capacity of responding to other questions, but would you agree that things are changing in terms of the perception of the prime objective of competition law? Back in the day, in 2001, I had published a book published by the Turkish Competition Authority, and this was called The Prime Objective of Competition Law from a Law and Economics Perspective. And the debate really felt like it's a debate between, social welfare maximization, i.e. total welfare maximization, versus consumer welfare maximization. Should we only concern ourselves with enlarging the pie as much as we can, and then its redistribution should be a subject of the policy tools of other legal disciplines, or should we concern ourselves with income distribution matters as well, and all that? Fighting inflation, should it be a goal? A protection of small businesses, should it be a goal? And I had written the book, and it was published, and ultimately I was taking the side of social welfare maximization, but to this day I don't remember any other era where people are discussing so many other potential objectives of competition law, or loudly broadcasting that they would directly see a difference between a cartel among private jet brokers versus a cartel in bread yeast. Both are cartels, both would demand resources of enforcement agencies, but one hits the rich, the other hits the poor, or everyone in one go. So, we're going to go after the second one. Would you agree that we're in a different era of perception of the prime objective of competition law, and if so, in what sense?
If I could start, yeah, I think you're absolutely right. Yes, the cartel for the jet brokers, yacht brokers, whatever it is, is a per se violation. In my view, it harms people who can take care of their own interests through private litigation, perhaps bargaining with the people who are ripping them off. They can take care of themselves, and it's appropriate to concentrate resources with the aim of protecting those who cannot protect themselves, and obviously the broader society. I thought the most elegant way I've seen a great explanation for why this frame has broadened is there's a lawyer and economist, Jonathan Baker, at American University in Washington, D.C., who's written a bunch of pieces. The best, the easiest, the most directly on point is called Antitrust as a Political Bargain. His argument is that, the Chicago School Revolution, in his view, isn't all bad. It focused on efficiency arguments that were being ignored, but it was part of a bargain, implicit or explicit, that the efficiencies and savings unlocked by permitting certain arrangements would flow to the broader society and those less fortunate. And he believes that they got the lenient antitrust enforcement, but they didn't get the benefit of the bargain. And if that's true, that's a really nice way to explain why there's been a broader interest in opening up antitrust and a broader interest in looking at the abuse of power. And so, I see that explains it in antitrust and in the whole broader thing, going back to Occupy Wall Street, to concerns about inequality. And, if you think about antitrust as a tool to control the abuses of power, you get both a broader frame and a natural interest in looking at what the EU and many, many other jurisdictions have always done, rather than the US more cowboy capitalism approach.
Jonas?
I mean, of course, there's an ideological debate issue. And of course, Thomas Piketty in his recent book, puts focus on the fact that the ideology might play, a driving role sometimes in, in the way also economic theory is generated. But I think, in this context, I will not talk about that, of course, but I think, 10 years ago, I wrote a paper about the goals of competition law, basically saying that, it's something that you need to answer after you have identified which are the institutions that enforce competition law. I mean, the goals in a system with courts might be different in, of course, playing a central role. It might be different from, the goals in a system where you have independent competition authorities, or a system where you have, the commission, which is not just a competition authority, but actually does a number of other things. Okay, so the institutional framework, I think, plays a very important role about the goals that you're going to have. So we cannot really have a universal answer to that question. Now, that said, I think because of the more economic approach and the what I have, I've called in a different paper, the separability thesis. I mean, issues of efficiency should be distinguished from issues of distribution, which is very much part of the neoclassical paradigm. I mean, competition law enforcement in the 1980s, during the the period of the integration of the more economic approach, have focused on social welfare. I mean, on economic welfare, basically. And in particular, total welfare, or a specific dimension of consumer welfare that would be just a consumer surplus, but not necessarily the transfer of wealth. Now, I think, the last few years has been a lot of work on looking a little bit to competition law as a broader, taking a broader perspective, looking a little bit as part of the social contract, if I can use the term of Michal Gal, or a form of social regulation, if I can actually use the term that I use in my work. And what we see also is that the concept of economic efficiency can be, can have different meanings. I mean, usually the people that have been the adepts of the more economic approach, that focus on economic efficiency from a point of view of output and price, but the way actually European courts use the concept of economic efficiency is different. I mean, in the Commission, of course, I mean, they are referring to other issues like variety, quality, innovation, consumer choice, and maybe, in the recent guidance of the European, I mean, draft basically guidance for the market definition notice. I think it's one of the, I think the first paragraphs in probably paragraph 16 or 15, I can't remember now. I mean, the Commission puts forward the idea that all the different parameters of competition, like sustainability, resilience, and others. So, you know, and you know, they make discussion about efficiency. So I think the concept of efficiency can be interpreted in different ways. And I think, you know, a very important aspect here is also the fact that, you know, we don't necessarily only now rely on economic models and economics as the, you know, the principal source of wisdom. I mean, we're opening up, particularly because of the use of data and the availability of data. We can also, you know, open up to different sources of wisdom, like, you know, complexity science, as I mentioned before. It could be economic sociology research, research on financialization, and also inequality. And I think, you know, this is something that might be integrated, you know, slowly into the competition law framework. I mean, at least one might argue for that, and competition authorities might invest in this type of research for their own work.
Yeah. So let's maybe close on the note of the very first question that we have tackled, and go back to the debate that we started all this with. Remember, I had asked if there might be too much focus on enforcement in digital markets. Could this be leading to under-enforcement in other sectors? And we have discussed this a little bit. I see a question from Nick Peristerakis, and he says, do you think there is a disproportionate focus on enforcement against the large digital platforms, given many other current issues facing consumers, such as high energy prices or other traditional hardcore abuses that take place in more traditional sectors of the economy? Now, this is a spin-off of the very first debate we had, but maybe to make sure that we're addressing a question, would you like to spend 2 minutes each on this particular question? Or maybe to focus my initial question, are we focusing too much on GAFAM? Might be a way of asking the question too.
If I may answer, I mean, and thank you, Nikos, for your question. I mean, you know, it depends on the competition authority. I mean, if you talk about the European Commission, I'm not entirely sure that the Commission has focused only on enforcing against large digital platforms. Actually, they're doing a number of other cases in the pharma sector, you know, energy, etc. So it's not that they have been focusing only on big tech. And again, you know, you have to think of the European system as a system. You know, in a sense, you have the Commission, but then you have a number of national competition authorities. And there's a lot of enforcement of EU competition law by national competition authorities, which might focus probably more on issues of, you know, energy prices or food prices in their own jurisdiction, because these are also local kind of related issues. Of course, you have the more global food value chain type of issue, but still, you know, a number of these type of cases concern, you know, supermarket chains and you know, the agricultural sector, which are basically national. So, I mean, taking the European system as a whole, you know, the European Commission and then national competition authorities, I don't necessarily think that there's a disproportionate focus of enforcement. I mean, it's probably more attention by the commentators and academia on digital, because that's really new and a whole issue. And you have all these new regulations come in, and how these will, I mean, the AI Act, the Data Act, the DMA, the DSA, Data Governance Act, and how these will interact with competition enforcement. So that's a quite interesting issue for academics. But I don't necessarily think that there's more enforcement about digital and less about other areas. Now, I don't know exactly in the US what's going on, but I guess similar, you know, you have also the states that are also enforcing state law and as well as federal law, I guess. And so in courts, you know, not in state courts. So maybe, you know, if you take the whole system, you know, it's less prominent, this focus on digital, than what we think.
Yeah.
So, you know, I can only I can only talk about what's in the public sector because I wouldn't know what's under investigation at DOJ. But when you talk about the Department of Justice, the FTC, the 50 attorney generals, and then all the private litigation in the United States, you see a mix of incredibly resource-intensive cases and investigations relating to the tech platforms. And then you see some of the hyper-local things that affect people's lives. So I'm physically in Chicago. There's a pending supermarket merger between two national chains that in Chicago mean that the two biggest supermarkets would be united. That's what's on people's minds. The FTC is doing these huge cases that they never have enough attorneys, they're never going to have as much resources as the defendants. But at the same time, they're litigating hospital mergers in a particular city where competition is likely to be harmed if the merger goes through. So it's just a mix. And there's no other way around that. It would be irresponsible to do either one or the other. And I've seen cases as localized as non-compete agreements that affect security guards and home healthcare workers in a particular area of Florida or something like that. And obviously, these litigation involving the conduct and acquisitions of the tech platforms, which are going to take years to resolve. And in most of those situations, the EU has acted earlier and has better tools in their toolkit. So it's a mix. And if we broaden it from just the US and the EU, I think it's a real challenge for a newer or smaller agency how much it wants to get into this resource-intensive game. It's just as important for their economies as it is for ours. But if you only have a couple dozen professionals to run an agency, it's a very hard question how many of those people you want to dedicate to one or more of the tech platforms, as we've been talking about.
Yeah, wonderful. Well, thank you, Ioannis Lianos, and thank you, Spencer Weber-Waller. Grateful to both of you. We've exceeded our time 5-7 minutes, but this was in an effort to respond to a question as well. And in general, I think, I hope this has been exactly what it promised to be. So without doing a very granular analysis of one particular matter of competition law, we have had very many broad looks into the evolution of competition law and different streams of competition law. I sure enough have learned a lot from it, and I thank you, thank both of you for that. And I look forward to seeing you in person, hopefully. And I also hope to circulate the video link of this particular video recording so that more people can take advantage of the wisdom, information, and know-how in this particular session. Thanks a lot, Ioannis, Spence.